Hello, Dr. T and classmates. This is Nicole Dalton, and this is my multimedia discussion board for MPA 545, week number 6. This week, I'll be covering alternative dispute resolutions. A little housekeeping before I get started. All of the journals and the news article that I selected are all identified in the individual slides, so you can follow along as we go through this presentation. And with that, I'll get started. The first ADR that I'll be covering is early neutral evaluation. And in both the textbook and the journal article that I found, it states that courts generally appoint a neutral party to help in these cases, which is typically going to be an attorney. And the cases that are typically covered for early neutral evaluation are personal injuries and employment discriminations. And again, in both the textbook and journal article, it says that it's important to have a neutral party in cases like this because there's a subject matter expert there to provide levels of their thoughts and opinions on both sides of the case, so they can generally stop the problem before it escalates to the point of needing it to go to court, so the parties can save money and stop the problem before it gets worse. The next ADR is mini trials, and in both the textbook and the article, it states that mini trials concentrate on critical issues with relevant facts of both sides while concentrating only on the legal permits of the case. Some of the things that will go to mini trials are contract disputes, patent infringements, and employee grievances. And a mini trial is going to be more expensive than a mediation or arbitration, but it is still going to be cheaper than if it were to actually go to court. And typically an attorney or a retired judge is chosen to hear the case in an informal setting, and there are not lawyers present. And in both the textbook and the article, it states that this is a voluntary process for both parties, and a mini trial will generally last about 2 to 3 days long. The next ADR is summary jury trials, and in both the textbooks and the journal article, it states that a summary jury trial is a non-binding trial that's typically done in about a day, and there's generally a jury that's selected to hear out both sides of the case, and they'll ultimately decide a verdict. What was interesting about a summary jury trial is that the jury is not going to hear from the witnesses themselves. They'll see a witness testimony that is provided by both of the attorneys, and this will help them make their decision. And so what's supposed to happen here is the jury makes their decision on what would actually happen if they were to go to court. And once they come to their conclusion, those two parties will again try to mediate the situation and come to a solution before it actually gets put into litigation. The last ADR that I'll be covering is dispute resolution boards. And in the textbook and the article, it mentions that these dispute resolution boards are generally used for civil infrastructure projects. And the board is typically made up of 3 panel experts who are independent and experienced individuals in this field. And what's important is that they're both respected by both parties. All of the board members are respected by the parties. And typically, the owner of the project will select one person, the contractor will select another person, and the two groups will jointly select a third member for their chair. And I think what's interesting about this is that during the entire project, the board members will be kept up to speed. They'll have access to plans and specifications and what's going on with the project, so that way when disputes do arise, they already know all of the information and they're going to be able to have an unbiased approach on how to resolve the issue. So the article really stated that dispute resolution boards are great for construction projects, and it's an easy way to have a mediator come in where there's already respect established. The news article that I've selected for this discussion board is tied to dispute resolution boards. And the news article goes into all of the different disputes that are happening due to COVID-19, and it argues that the most successful ADR for COVID-19 disputes is dispute resolution boards. And this is for a number of reasons. One being that these parties have to have ongoing and future relationships with one another after the dispute. And it also explains that these dispute resolution boards are short and flexible procedures so that it can be used effectively and it is cost effective as well. So the hope is that using this dispute resolution board, so that after the dispute is settled, these parties can go back to normal and their regular business. Thank you all so much for listening to my presentation, and I hope you all have a great weekend.